My name's Anna Fletcher and I'm a director in the employment team at Wragge Lawrence Graham. I deal with a wide range of employment issues, particularly on the contentious side of employment law. The issue over the calculation of holiday pay has really been on the agenda throughout this year. We were aware from the end of 2012, following the British Airways and Williams litigation, that there was an issue potentially about extending monies that needed to be included in the calculation of holiday pay. Back in 2013, we started to see a little flurry of tribunal decisions where the tribunals were looking at payments such as overtime payments and commission payments, determining whether they should be included. The whole issue is, following the BA and Williams litigation, that anything that amounts to normal remuneration, so anything which is intrinsically linked to the performance of the contract of employment, should be included in holiday pay. So we have had a number of these tribunal decisions, all now consolidated. They were heard before the Employment Appeal Tribunal at the end of July this year. And in fact, on the 4th of November, the Employment Appeal Tribunal handed down its judgment. It's confirmed that anything that amounts to normal remuneration should be included, which I think is probably the position that we all felt was the likely outcome of those appeals. Where we have a bigger issue is actually how we go about calculating what amounts to a series of deductions. The Employment Appeal Tribunal were very clear that simply an underpayment going on month by month couldn't of itself continue to be a series of deductions. So there's going to be a big issue here about whether or not people will be able to leapfrog their claims back to either the start of employment or the 1st of October 1998, if in fact they were employed at that point in time. We know that this is going to be appealed to the Court of Appeal, so this is really going to be, I suspect, the hot issue for 2015. So lots of issues about uncertainty left by that particular aspect of the decision by the EAT. So we need to sort of see where we get to with the subsequent appeal. It's not particularly helpful for some employers because, of course, we still do have that unanswered question about the level of the past liability. But certainly going forward, it allows employers now with certainty to determine what needs to be included in the calculation of holiday pay for the purposes of certainly the working time regulation element, the Regulation 13 leave, so in other words your 20 days leave. We know that the decision in Locke, which was heard by the Court of Justice of the European Union early this year, is going back to the tribunal. That's the case that involves the inclusion of commission payments in the calculation of holiday pay, and that will go back to the tribunal, I think, in February next year. It was due to be heard in October this year, so it's been delayed somewhat. So again, something else to be mindful of on the horizon. On the 4th of November, Vince Cable announced that a task force will be established to look at this issue of holiday pay and past liability. So I think that, coupled with the appeals to come, almost certainly will lend itself to keeping a very close eye on this area during the course of 2015.